I just started it.
Okay. Commissioner Candelaria, are you present? Yeah, in the background.
Yes, I am.
Oh, okay, thank you. Commissioner Dominguez,
Present.
Commissioner Fry,
Present.
Commissioner McWilliams,
Present.
Commissioner Commissioner Patton. He did say he was going to be gone. Commissioner Raider,
Present.
Vice Chair Cipher,
Present.
Commissioner Thompson. Who might be stuck in traffic? Commissioner Velasquez,
Present.
Commissioner Vehil,
Present.
Commissioner Zemlik.
Present.
You have a quorum. Commissioner Patton won't be here, and we'll check in with Commissioner Thompson shortly when he lands someplace.
Thank you. We have next on the agenda the approval of the April 11th meeting agenda. Would you get a motion on
Chair
that?
Cipher,
Yes.
this is Council Sanchez. As I indicated before the meeting started, we're back to mandatory in-person attendance by the commissioners with the expiration of the declaration of a public health emergency. Under the Open Meetings Act, in-person attendance is required absent showing it being otherwise difficult or impossible for that member to attend in person. So if we could have those commissioners that are attending virtually to state on the record sequentially or individually why they did not appear in person. We'd like to have that for the record, please.
Council Sanchez, Commissioner Patton sent me an email that he was not going to be here. He had an appointment. And Commissioner Thompson is en route. And I believe everyone else is here.
Armstrong.
And our interim appointee is online. And I didn't call him because he's not, we haven't introduced him yet.
Commissioner Cavallari.
Okay, that's fine.
I'm
Thank you for checking.
Wait, hold on a second. Council, I've been reminded that Commissioner Candelaria is online. So
Okay,
Commissioner.
Yes,
Yes.
I apologize. Yes, I don't know if I may have made a mistake here, but I was going based off of the email sent April 7th regarding if we had to drive into Santa Fe that we should appear virtually due to budget constraints. Otherwise, if I didn't receive this email, I would have been there in person. I just thought we were instructed to appear virtually.
Okay, thank you, Commissioner. And does that do it for those that are attending virtually? I believe that.
I didn't call designate Armstrong. But
Okay.
he is online. He is virtual.
Okay, we'll be introducing him on item 6 and we have a quorum without him, correct?
Yes, you do.
So we can consider his appointment effective, I believe, according to the secretary designee that that would be effective today. So we'll do that as the process of the meeting. Is that sufficient, Council Sanchez?
yes, it is Vice Chair Cipher. Thank you.
Thank you.
Commissioner Cipher,
Yes.
before we proceed, I spoke with Council Sanchez this morning, who advised that I make a disclosure about a potential conflict of interest, or just make a disclosure to the commission who's now determined to do so.
For what agenda item?
So for general items, any cases having to pertain to Department of Energy, I was approached by Department of Energy, U.S. Department of Energy for a general competency interview last Friday and participated in that interview. Generally speaking, for the Clean Energy Corps, nothing that should relate to any of the offices in the Department of Energy that we have before us in any of our cases, but
So will you be abstaining from voting on any of those issues?
council advised that it should not be a conflict of interest, but out of abundance of caution, I should make a disclosure.
Okay. Thank you. Council, should she go ahead and abstain from voting today as well?
Vice Chair Cipher, to err on the side of caution, I think it'd be preferable if she abstained on any votes on which or in which the DOE or a related entity is a party in a proceeding. Thank you.
Commissioner, are you comfortable with that?
Absolutely.
Okay, we'll do that then. Okay. No problem. Let the record note also that Commissioner Bruce Thompson has arrived. Thank you. So we're on item 2, approval of the agenda, today's agenda. Do we have a motion?
I motion that. Morning.
Second. Thank you. I have a first and a second. Roll call, please, ma'am.
Yes, Commissioner Breichert, how do you vote?
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Raider,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlet.
Yes.
The motion passes.
Thank you. And now, item 3 on the agenda is approval of the January 10 minutes. We'll accept a motion for approval. Or any comments or corrections?
Mr. Vice Chair, I would make a motion that we approve the January 10th meeting minutes as presented.
Thank you. And a second by Commissioner Brayton. Ma'am?
Set. Commissioner Breichert, your vote?
Yes.
Commissioner Candelaria,
Yes.
thank you. Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Raider,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlet.
Yes.
The motion passes.
Thank you, ma'am. Item 4 on our agenda is public comment, general comments not pertaining to particular meeting agenda items. Do we have anyone signed up for that?
No, sir.
Anybody in the audience? Seeing none, we will proceed to item 5. This is my favorite part of the agenda today. We will be accepting nominations and elections for WQCC Chair and Vice Chair. To be effective tomorrow, I will chair the remainder of this meeting today. And then those offices will also be in force at the next meeting, which is expected to be May 9th. So with that, is there any nominations that people would like to make? Commissioners?
Vice Chair Cipher, if you would, please, let's take each position first. If you'd open the floor for nominations on chair first, and
Absolutely.
then once we're done with that, we'll go with the vice chair.
Thank you. Thank you. So the floor is now open to nominations for chair.
I nominate Commissioner Thompson. He said he would do it if no one else would.
I second
You feel like you're on the railroad? Any other nominations? We declare the nominations for chair closed. I guess, do we need to have a vote since there's only one candidate? Yes, we do.
Let's have a roll call vote, please.
Okay, Pam?
Okay, roll call vote for Commissioner Thompson to become the chair. Commissioner Brankert, how do you vote?
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Raider,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson, okay. Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
Congratulations.
Indeed. We really have, elected someone that's very qualified, and we sure appreciate your willingness to serve. It is not an easy task. I will bloviate for one moment that, I got my eyes open being vice chair, and Commissioner Dominguez, is clearly, I don't know where. But this is, just almost a full-time job when you're doing it right. And I didn't feel like I had the time with my 45, 50 hour a week job that I already have to really do the job justice. So I didn't feel like I was an appropriate candidate, but I think that Bruce Johnson is, and Commissioner Thompson, we appreciate you. Thank you. So that moves us to the nominations for a vice chair. What is an easy job until the chair is gone. Awkward silence, but I think we'll leave it open for at least a minute. Yes,
I would nominate Commissioner Raider as vice chair.
Commissioner Raider, would you accept that nomination?
If we do not believe that there will be any serious conflicts of interest, given the DOE's interest in me, however tentative, I would be happy to serve if no one else is. Similar to Commissioner Thompson, I will take his stance.
Council Sanchez, can you weigh in on her comments?
I don't know how matters will unfold for the commissioner, but certainly if she takes employment, that would be, I think, an ongoing problem. But for now, it would appear that we don't have, at least not an immediate problem.
Good. Comfortable?
I am happy to continue to disclose as that very strange interview process continues.
Okay. Thank-
I would second the nomination.
Okay. I didn't really want it seconded until she weighed in, but thank you. That's perfect. Was there any other nominations before we close? Okay. In that case, Pam?
Commissioner Brankert, how do you vote?
Yeah.
Commissioner Candelaria,
Yes.
thank you. Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Raider,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
The motion passes. Congratulations.
Yes, congratulations. Our next item on the agenda is the introduction of Jonas Armstrong, the New Mexico Environmental Department Cabinet Secretary's interim designee. We hope interim becomes long and maybe permanent. I will say that Jonas is well qualified. He's got his Juris Doctors from University of New Mexico School of Law. He has his undergraduate also at the University of New Mexico. He's worked for the Interstate Stream Commission, and he's worked for the city of Albuquerque. He's worked for the Public Regulations Commission. He has been involved with and worked with the Legislative Finance Committee. He has published work. Jonas, we're very proud to have you as part of the team, and welcome aboard.
Thank you, Acting Chair. Apologies for not being there in person this morning. I got the same guidance that Commissioner Candelaria got in terms of budget restrictions, but I also was heading up this morning despite that, and with the traffic predicting me to get there 30 or 40 minutes late, I decided to turn around and attend virtually.
Thank you for that. Just a point of order, Council Sanchez, can you advise as to whether Jonas may vote for the rest of the meeting, or what is his status?
Yes, he's able to vote going forward.
That's wonderful. Thank you. And thanks again, Commissioner Armstrong. We appreciate you being aboard.
Thank you. Looking forward to it.
Great. Item 7 on the agenda is approval and adoption of our Opens Meeting Act resolution. Councilor Sanchez, will you take that one, please?
Yes, thank you, Vice Chair Cipher. Commissioners, I believe in your packet, you have a copy of the proposed annual resolution. As I think most of you know by now, the Open Meetings Act requires all public bodies, of which the commission is one, to determine annually what constitutes reasonable notice to the public. The resolution that's in your packet resembles very much the same resolution that the commission had adopted and approved prior to the public health emergency. The one difference is that paragraph 10 has been modified to allow for public participation and attendance and participation by virtual meeting platform. So looking at it differently, it also looks very much like the last resolution adopted by the commission, except that the last 4 recitals of that resolution have been deleted because of the expiration of the public health emergency, and paragraph 10 has been modified again to no longer speak to a state of public health emergency, but rather to provide for a virtual platform meeting. Thank you.
With that explanation, Councilor Sanchez, do we need to read the resolution or just the title?
I don't think so. I think every commissioner's had an opportunity to review it. It's an entirety. I'll certainly be glad to answer any questions or respond to any comments. But absent that, you can then go ahead and take a vote to adopt the resolution as submitted, absent again any changes that may be required.
Okay, thank you. So I'll accept a motion and a second, following which we'll have opportunity for comments or questions.
Mr. Chair, I have a question. Is there a resolution number right now? It's listed on my.
It will be 2301.
Thank you, Council. With that, I'll take a motion.
Commissioner McWilliams will motion that we adopt the Open Meetings Act annual resolution number 2301.
You, second. Do we have a second by Commissioner Dankert? Pam? Oh, wait, I said that I would give opportunity for further questions at this point. Is there any clarifying questions that anyone has, the commission has? Okay, Pam?
Okay, to accept the OMA Resolution 23-01. Commissioner Brackert, how do you vote? Commissioner Candelaria?
Yes.
Thank you. Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Armstrong? Thank you. Commissioner Rader?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Vehil?
Yes.
Commissioner Zemlik?
Yes.
The motion passes.
Thank you, Pam. The next item on the agenda is WQCC number 20.
Yes. I have a question about item 10 for council. It says the commission in its discretion may provide for a hybrid public meeting. Should the commission take some action to sort of authorize those in the future now
Item 10?
on the Open Meetings Act resolution?
On the resolution. Council,
So Commissioner Rankin, I don't think that's necessary. Certainly when the commission schedules its next meeting, we can certainly have the commission state that it will be a hybrid meeting. So no, I don't think we need to modify that.
Okay.
good. Thank you, Council. With that, was there any other questions before moving on? Okay. Item 8, item on the agenda is WQCC number 22-42A.
He's gonna sit next to you.
The hearing officer Gregory Shakalan, would you take that one?
Thank you. I'm calling to order WQCC number 2242 in the matter of the petition for permit review of discharge permit 1342, City of Gallup petitioner, New Mexico Environment Department's Groundwater Quality Bureau respondent. I was appointed as hearing officer on October 28, 2022. We are proceeding under rule number 20.1.3 New Mexico Administrative Code, or abbreviated as NMAC. The parties originally were provided a scheduling order by myself under 20.1.3.16, which is the permit review section of the rule. They have chosen to proceed instead under the alternative resolution part of the rule. That is 20.1.3.22 NMAC. This part of the rule allows the parties to negotiate a settlement. Under subsection B of the rule, the commission does have to approve the settlement agreement after hearing evidence. And that's what we're here today. The hearing today will be to take evidence and then for the commission to deliberate and decide, or if the commission would prefer a hearing officer's report, it's in their discretion to order one. In this permit review under section B2, it says the commission may approve a settlement that modifies a permitting action only after evidence supporting such modification is presented at a hearing. I issued an amended scheduling order based on the parties' joint motion to not schedule a hearing, suspend briefing, and present a settlement agreement. And we have a notice of intent to present technical testimony submitted by the department. The petitioner is not submitting a NOI or notice of intent. They're going to use the department's witnesses to their benefit. This was filed on March 30th, the last day of the time to file technical testimony after the parties asked for an additional 3 days. The parties today have one technical witness, and that would be Jason Herman, who I see is here, sitting next to me. I'll let the parties introduce him. There are 3 exhibits for consideration. There is Exhibit 1, technical testimony of Jason Herman. And the reason that the parties submit it this way is so that they can have the full written technical testimony as evidence in this hearing. Mr. Herman can provide a summary for the commission and the public. We also have Exhibit 2, which is the settlement agreement itself. This was included in the commissioner's packet. And we have a resume of Mr. Herman, and that is Exhibit 3. So before we proceed, let's deal with these exhibits. And counsel for the Groundwater Quality Bureau, would you introduce yourself?
Good morning, Mr. Hearing Officer, Vice Chair Seifert, members of the commission, and Chris Atencio, counsel for the Environment Department, Groundwater Quality Bureau.
And are you offering these 3 exhibits into evidence?
Yes.
And do we have counsel Herman?
Mr. Examiner Keith Herman, on behalf of the city of Gallup. Also present with me is the city engineer, Mark DePauli, with DePauli Engineering. He is just present if there are any questions for the city today, but subject to one procedural matter that I would like to discuss before the admission of Exhibit 1, we do not intend to present any direct testimony today.
So, Mr. Herman, before you get to your procedural matter, under what rule or under what condition would your witness answer questions?
I'm not sure if there's a specific rule, just the general hearing procedures. Should any matter come up that the commission would have a question of Mr. DePauli, he's available.
We'll deal with that at the time. That's the correct time. Did you have a procedural matter?
Yes, Mr. Examiner. Having reviewed Exhibit 1, the city does have an objection to one sentence that's included on page 5, starting at line 2 with the sentence beginning with the permittee and ending at line 5 with the word inaction. The city objects to that sentence and moves to it being stricken on grounds that it is inadmissible hearsay, and it misstates a position of the city in its request for a permit review. Otherwise, striking this sentence has no other impact on the testimony of Mr. Herman, and we have no other objections to his testimony being admitted as evidence.
So, Mr. Herman, before I turn to Mr. Atencio for his response, you do realize that the rules of evidence are not in effect, and the hearsay objection is not it would not be sustained.
I'm sorry, Mr. Examiner. Which Mr. Herman are you referring to?
Are there more than? Well, Mr. Herman, I wouldn't be referring to the witness who hasn't been called yet. I'm referring to you. You made the objection.
We just want to make our objection for the record. If it is sustained, then so be it. But one of those speak now or forever hold your peace opportunities at hearing.
Mr. Atencio?
Mr. Hearing Officer, the department doesn't have an issue with that being struck. That's fine.
Okay. So, Mr. Herman, that sentence will be struck from the exhibit before it is considered. Now that it is struck, are you opposed to its admission into evidence?
No.
Yeah. So Exhibit 1 is admitted into evidence. Exhibit 2, are there any objections? Mr. Herman?
No objection.
Exhibit 2 is entered into evidence. Exhibit 3, Mr. Herman?
No objection.
Exhibit 3 is entered into evidence. Does that cure all of your procedural issues?
One point of order. Was this going to be done after Mr. Jason Herman was sworn in?
Those exhibits are entered into evidence by stipulation of the parties. It doesn't require Mr. Herman to be sworn in. Mr. Herman, are you ready to testify? Okay. Would you please swear in with us?
You solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. And I'm gonna ask everybody, to please keep their voices up for me.
Would you say and spell your name, please?
My name is Jason Herman, JASONHERMAN.
Mr. Atencio?
Thank you, Mr. Hearing Officer. Good morning. Thank you, members of the commission. This matter is a permit review, as the hearing officer said, that came on 20.1.3.16 NMAC. After the permit review petition was filed and subsequently granted, the parties engaged in settlement discussions and were able to reach an agreement. Here today is Mr. Jason Herman. As you noted, he's provided pre-filed written testimony that's been admitted. I just have a couple of questions for him, and then we'll make him available for any questions you might have. Mr. Herman, can you please briefly describe your education and experience?
Sure. I have an undergraduate degree in environmental planning and design and 2 master's degrees, one in community regional planning and one in resources management from the University of New Mexico. I have worked here at the department for 6 years in the pollution prevention section, where I started off as a permit reviewer and then was promoted to a domestic team leader. And I am currently now, for the last year and a half, the program manager of the pollution prevention section, where the discharge permitting program for the Groundwater Quality Bureau exists. I have provided technical testimony in 3 permit hearings for different types of facilities, overseen many different types of facilities in New Mexico, including uranium enrichment facilities, Department of Energy facilities, and even as small as mobile home parks. And I have participated in enforcement actions for all the same things all around.
Thank you. And did you pre-file written technical testimony in this matter?
I did.
And you adopt that today?
I did.
Can you provide just a couple sentence summary of that testimony?
Sure. So 2 major issues were at question. The first being arsenic sampling frequencies, and the second being monitoring well construction for the facility. And we entered into a settlement agreement to provide alternative methods that are written into the permit. The arsenic reduction in sampling frequencies was justified through an explanation and description of the necessary level of evidence to reduce arsenic levels. You said 2 sentences. I think I'm on with that. As well as for the monitoring wells, we came to an if-then statement settlement agreement that would be really difficult, almost impossible to do within a permit condition, and therefore is much more appropriate for a settlement agreement, and have determined that it's also as protective as the permit conditions that were provided.
Thank you, Mr. Herman. That concludes my questions, and Mr. Herman's available for any questions from the hearing officer of the commission.
Mr. Herman, are there any cross-examination questions for this witness?
No, Mr. Examiner.
Commissioners, are there any questions for this witness? Mr. Riker.
Chairman, I did not see among the exhibits a copy of what the new discharge permit would look like. The parties agreed to a form, an actual form of the discharge permit.
Thank you for the question, Mr. Commissioner. We would not actually have any modifications to the permit conditions themselves. We would provide the settlement agreement as a superseding document to the permit itself, to the permit conditions. So it would be an attachment. This has been done previously in the Club Rio Rancho permit for those issues of the bonds. And we provided a supplemental settlement agreement.
Okay, thank you.
Are there any other commissioners with cross-examination questions for this witness?
Mr. Herman, was the only quantifiable permit addendum, as it were, the arsenic?
Thank you for the question, Vice Chair Seifert. The two issues at hand were the arsenic sampling requirements and the frequency, and then monitoring well installation and how we approached and went through the process of requiring those monitoring wells or not requiring those monitoring wells, depending upon the results of the initial installation.
Thank you, but the only element that was identified was the arsenic.
In the discharge itself,
Yes.
sorry, I'm not supposed to ask you questions. Yes, that was the only exceedance that we identified in monitoring during the previous discharge permit term, and was what was of concern and why we increased and added it to the discharge permit.
Thank you so much.
Are there any other questions for this witness? From the public, are there any questions? Not hearing any. Is there any redirect on those questions?
No, Mr. Hearing Officer.
Is there a rebuttal case?
No.
Do you rest your case?
Yes, sir.
Okay. Mr. Herman, you had the opportunity to submit technical testimony in advance. It wasn't done. You're relying on this one witness for the commission to approve or deny the settlement agreement. So I'm going to close this hearing and allow the commissioners to proceed.
Thank you, Mr. Examiner.
Mr. Sanchez?
Yes.
Is this your opportunity now to counsel the commission on how to deal with this issue?
No, I think they know what they need to do. The settlement agreement, the proposed settlement agreement is before them as an exhibit. They've had an opportunity to ask questions. They can now look to the settlement agreement and decide whether they want to approve it pursuant to subsection 2 of the rule or disapprove it under the following subsection, which is subsection 3.
Thank you, Council Sanchez. Vice Chair Cipher?
Thank you, Hearing Officer Chikita. Commission, before us is then a decision whether this settlement agreement, whether we would approve it or disapprove it. Are there, at this time, it is our time to deliberate that. If there is clarity here, we can go ahead with a motion, but if you'd like to deliberate it, are there any comments? Commissioner,
Mr. Vice Chair, prior to deliberating, maybe just to cover a procedural matter, there also was at the beginning of the hearing officer mentioned that there was also the opportunity, if the commission deemed appropriate, for a hearing officer report, recommendation, etc. I would, just as a point of discussion, I believe the commission can probably move forward with deliberations with what's been presented to us, both in writing and through the testimony today, and do not see a need for a hearing officer's report.
Thank you, Commissioner Dominguez. Any other comments or any strong feelings that we need a report?
Vice Chair Cipher, just a quick reminder, should the commission want to refer to the actual proposed settlement agreement, they can go to the docket page and it is NMED Exhibit 2.
Thank you, Counselor. Any other comments? If not, I would entertain a motion to deny or approve the settlement agreement.
The Vice Chair,
Yes.
I move that the commission approve the settlement agreement at WPCC number 22-42.
Thank you.
Vice Chair? Yes. Okay.
Sure. Pam, would you do a roll call, please?
Yes, Commissioner Brankard, your vote?
Yes.
Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Armstrong?
Yes.
Thank you. Commissioner Raider?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Vehil? Commissioner Zemlik?
Yes.
Vice Chair, the motion passes.
Thank you. With that, we will move to item 9 on the agenda. I have,
Excuse me, Vice Chair.
yeah,
Vice Chair Cipher, just one quick matter before we do move on.
yes,
I'd ask that council submit a proposed form of order approving the settlement agreement to me. Thank you.
okay.
Vice Chair Cipher, Councilor Sanchez, that proposed order was submitted with, previously by the city of Gallup, and it should be with the packet of materials.
Thank you. I appreciate that. Is that in Word?
Yes, I believe it is.
Yes.
Yes.
Okay, thank you.
Thank you, Council. With that, that brings us to item 9, WQCC number 2221A. There is, the hearing officer, I believe, has talked about the recommendation, or in his recommendation, the topic of jurisdictional issue. At this point, it's been brought to my attention that perhaps it may be appropriate to delay action until May 9th, when we would hear or be provided other information. Hearing Officer Chikalan, what is your thoughts on that?
I'm not sure what other information you are expecting.
Okay. I believe there is going to be some action proposed for the 9th. Is that correct, Council Sanchez?
Vice Chair Cipher, if my recollection is correct, and hearing Officer Kagan can correct me, the last scheduling order that I recall having been entered had set the matter for a hearing on the merits for the May 8th, or rather May 9th meeting of the commission. And then after some briefing, hearing Officer Kagan asked council to brief the single issue of subject matter jurisdiction. I think as a matter of expediency, the commission can hear the question of subject matter jurisdiction as a preliminary matter on May 9th, and then depending on the outcome, proceed accordingly. That's routinely done by administrative bodies and certainly courts of law before a matter is heard on the merits. On the day the matter is scheduled for a hearing on the merits, all preliminary matters are typically heard beforehand, and then the matter proceeds accordingly. Thank you.
Hearing Officer Chikalan, would you like to respond?
Standing is a critical issue when it comes to this permit review. The statute only allows parties who have been adversely affected to challenge the permit. This is a issue that gives the commission the power to rule on whether or not the evidence supports the permit or not. Standing can always be challenged before the hearing, during the hearing, after the hearing. Because if the commission does not have subject matter jurisdiction over the issue, it can't make a decision on it. It's not within its purview. This matter has been before the commission now since June of last year. The petition that was filed must comply with the rule 20.1.3.16, and the statute. In the rule itself, under permit review, the rule specifically says under subsection A1A, timing and contents, a permit review petition shall, A, not what we're talking about, B, identify the petitioner and state that the petitioner has standing under New Mexico statutes annotated NMSA 1978, section 74-6-5, subsection O, or 20.6.2.3112 NMAC to file the petition. Now, instead of challenging this issue on whether or not the petitioners have shown that they have standing under the law, for some reason, the other parties, NMED and LANL, did not challenge the standing at the time the petition was filed. Instead, they allowed the commission to appoint me as the hearing officer. They allowed the petitioners to file their opening brief. Now, the opening brief also, there's an opportunity there for petitioners to demonstrate that they have standing. For those non-lawyers in the room, standing just means I'm going to interpret it myself. I mean, the statute said that our legislature has restricted the parties that can file a petition for review to only those people who have been adversely affected. So in other acts, anyone can challenge a petition. Anyone can challenge a permit, anyone at all. But in this case, in this Water Quality Act, the legislature has said, no, not everyone, just this subgroup. It is the burden of that petitioner to show that they meet that condition. We call it standing because basically it allows them to stand before the forum and invoke the power of the forum to remedy what they consider is a wrong. So I waited, and on March 16th, the only opportunity that I won't call them the respondents, we'll call them the permittees, LANL, or the department. The only opportunity they had to address this issue before the hearing was to bring it up in their answer brief. Both parties, LANL and New Mexico Environment Department, filed answer briefs. In their answer briefs, the permittees said, wait a second, we're challenging their standing to even bring this permit review. Doing my job as hearing officer, I went back through and looked for facts because that's what I'm supposed to do. I looked for facts, and at this stage of the proceeding, I give those facts. I consider those facts to be true. I don't have any other evidence to compare with those facts. I don't have the right to judge the facts. I'm not the judge, the trier of fact. The commission is the trier of fact. I'm the hearing officer, and my role is specifically laid out in subsection 10 of this rule. I also can't make a final decision on standing because that would be a dispositive decision, which would mean that my decision could end this permit review. So I can't do that. What I can do is I can gather all the facts for the commissioners and allow them to do their job. Now, the reason that I submitted an order of briefing is because upon my review of the original petition and the opening brief, I didn't see standing. I didn't see that they had alleged enough facts to satisfy their burden of standing. So I issued an order of briefing on all the parties and said, I want everyone to give it their best shot. They submitted them on March 30th, spent the next weekend and several days thinking about it, doing legal research, and I put together a hearing officer's report. I did this because I was advised that the public notice for this hearing, because it was supposed to occur today, the hearing on this permit review should have occurred today. Now, it's not a typical hearing either. Under subsection 16 of the rule, the petition for a permit review only allows oral argument. It does not allow, similar to the Cannon matter, which you had before you and the commissioners who were here, you had before you, I think it was in October. The record, the factual record is already closed on this matter. No parties have asked me to add any documents to the administrative record for your consideration and for their oral argument. Therefore, what would have occurred today is the three parties would have had 45 minutes or so each to have made an argument before the commissioners, and then there would be a hearing officer report, and then you would deliberate on the facts, and whether or not you feel they have done their job and that the groundwater permit should be in some way denied or modified or approved the way it stands. That's what would have happened today had the public notice been properly noticed, but it was not. And I was told about 30 days ago that it had not been published properly. So we bumped it to the May 9 agenda so that the public notice could be done properly. In the meantime, after I heard about that, then came in the answered briefs that challenged standing. To deal with standing today would be expedient and conserve judicial resources, because if the petitioners don't have standing, the case is over. And they don't need to submit they don't need to submit, they don't need to prepare for oral argument, because there is no technical testimony. In this case, all the evidence is already in the administrative record. So they don't need to prepare for oral argument. The commission doesn't have to reserve time in May to have oral argument. And that's why I issued my report, to give the commissioners all the information that they need to determine whether or not the petitioners have standing, so that we can continue to May 9 or not continue to May 9. So I hope that explains everything.
That's very helpful. Thank you for that review.
Mr. Vice Chair.
Just one moment. Commissioners, with that being said, is there any questions or comments of hearing officer Chicane? Okay. Besides what was said by hearing officer Chicane, was there any comments or questions? Commissioner Branker?
Thank you, Mr. Vice Chair. I appreciate the hearing officer sort of bringing this issue out of the open and allowing the parties to really have additional briefing issues. It's an extremely important question, one of which the precedent for it is a Water Quality Control Commission decision in the Court of Appeals. I do appreciate that, but I agree with Council Sanchez that since this is a dispositive motion, it was best be heard as part of permit review next month's meeting. I think the way next month's meeting could work would be we would hear the arguments in that case. If we decide that the petitioner does not have standing, the case is over. If we decide the petitioner has standing, then it can go back to the hearing officer for a recommended decision based on the record. So that's the way I see it. I just think it better fits in, because it's dispositive, it better fits in with the whole permit review concept, which is sort of iced into our rules. It's the thing we have to do.
Thank you, Commissioner. Mr. Dominguez?
Thank you, Vice Chair. Going off of what Council Sanchez had recently brought up, that usually the issue of standing will be addressed prior to any hearing. As he pointed out, that would be addressed prior to, as he indicated, with other cases, that's typical for it to be brought up at the beginning of the hearing, not after a hearing. So that makes me pause. From the fact that if the issue of standing appears to me needs to be addressed prior to a hearing, rather than going through an entire hearing and then indicating, yes, they're standing, no, there isn't standing. So, to me, it's a matter of, it appears the standing issue needs to be addressed either today or before going into a hearing. Because, and I understand what my fellow commissioner brought up, but to me, it seems to be a moot point to go through all of oral arguments, etc., dealing with the permit review if there's no standing to even address the permit. To me, there's nothing that will come out of arguing the permit to address the standing issue. They either have standing or not. The arguments that would be before us on the permit is dealing with the permit itself. So to me, even if we push it off till May, it would be the very first thing done prior to going into the hearing. If the hearing is to argue standing, that's a totally separate issue. But the hearing is for the permit. So I don't think there's anything brought up during the hearing that deals with standing. It's a separate component. And as the hearing officer has indicated, if there is no standing, then the hearing goes away. You have nothing to decide there. So, to me, the issue of standing has to be addressed prior to going through the formalities of the permit review hearing. So we either do it today or we do it at the very beginning prior to the actual hearing. There is no use of having a hearing if there is no standing.
Thank you. Any other comments from the commission? Okay. Mr. Lovejoy, please keep it brief.
I will.
Thank you.
Thank you, Mr. Vice Chair Seifert.
Yes.
You have Commissioner Armstrong and Council Sanchez who both had their hands up.
Oh, I'm sorry. I did not.
That's
see
okay.
that.
I was looking at the screen.
thank you for sharing that. Sorry, Mr. Lovejoy, I want to get the council's, or rather the commission's, thoughts first. Mr. Armstrong?
Thank you, Chair. I just wanted to echo Commissioner Dominguez's statements in terms of my understanding of the order of operations that we would address standing before going into a hearing, and that to wait until next month and have on the agenda to deal with standing, and then also potentially the hearing. I understand what the hearing examiner is saying to us, that would be asking the parties to prepare for a hearing that might not happen depending on the commission's determination on the standing issue. And I don't know that that's the most efficient use of resources.
Thank you, Commissioner. And I am sorry, I believe there was one other commissioner.
No, Council Sanchez.
Oh, Council Sanchez. Please, go ahead, Council.
Thank you, Vice Chair Cipher. I'm not going to belabor the point. Everyone has, I think, made clear what the issues are, and Hearing Officer Chikadin in particular has laid out a very clear chronology and what the issues are. I just wanted to clarify that I'm looking at the amended scheduling order that was entered on March 15th. And just so the commission is clear, the only thing that is now pending are oral arguments. There are no evidentiary matters. There's nothing more than oral arguments, and that would be according to the amended scheduling order for the May 9th regular agenda or regular meeting rather. But it's entirely a matter of the commission's preference. They can hear the issue of jurisdiction today, or they can hear it as a preliminary matter on May 9th prior to, and again, to be clear, oral arguments. Thank you.
Thank you. Commission, one last chance for clarifications or thoughts.
I'm waiting for any other commissioner, but since no one has said anything, I know Mr. Lovejoy wants an opportunity to argue his point further in front of the commissions. I don't think that's proper. And I don't think it's proper because the other parties are not here to do the same, and today is not a day of oral argument. Everyone had an opportunity to file, and they filed a 20 or 30-page document. I don't remember how long it was. They had their opportunity. They even provided comments to my hearing officer's report, which the rule does not allow for comments to my report. And so they were not posted. However, I believe the commission has enough information to make a determination on standing. I think it's efficient to do it today. But if the commission would prefer to hear oral argument from the parties and consider my report, maybe we could schedule an oral argument on May 9, just on the basis of standing. And if you determine that they do have standing, then either after that could come the oral argument on the permit review on the substantive matter, or it could be bumped down another month to June. I think those are some options in case that helps.
I would, thank you. You're not so. I would like to ask the commission just kind of a blunt question here. And that is, do you feel you have the information you need? Should we make a decision today on standing that you could come to a conclusion? Somebody has their hand up. Yes, Commissioner Candelaria.
Thank you, Vice Chair. I think for me, it would help me to hear oral arguments based on standing. I would just feel like having that information would assist me in going forward. Thank you.
Thank you, Commissioner.
Chair Sarver, you have another commissioner with his hand up?
I think I'm blind.
Commissioner Irvin.
Oh, yes, Mr. Armstrong, thank you.
Thank you, Mr. Chair. I agree with Commissioner Dominguez, or sorry, Commissioner Candelaria, that hearing from the parties on the standing issue would be helpful for me also.
Okay. If we assumed for a moment that that is what we wanted, would the appropriate time for that be at the next May 9th meeting, or would that be I don't believe all the parties are here. Is that what you stated?
Correct. They're not.
I hesitate to open this yet to everyone, counselor, but Council Sanchez, my question to you is, I agree with Hearing Officer Shakalin's point of not opening this up to the body right now because we don't have a full contingent. But at the same time, I want to know when, if we were to follow the guidance of Councilor Candelaria, that appropriate time would be, in your opinion.
Vice Chair Cipher, we have an amended scheduling order for setting oral argument for May 9th. I think it would be entirely appropriate, particularly because we don't have all, we have two commissioners that have requested oral argument on the issue of standing. We don't have all the parties represented here today to be able to do that. We could certainly on May 9th allocate 10 minutes each for oral argument on the issue of standing. And then depending on the outcome of that, the commission's decision on that issue, either end the matter or proceed to oral argument. I see no problem with just providing 10 minutes or so, or whatever may be appropriate for oral argument solely on the question of standing. And then depending on the outcome of that issue, proceeding or not proceeding to oral arguments on May 9th.
Thank you, Council. Councilor Tizio and Councilor Lovejoy, I'm of the opinion that I'm going to ask for a motion, and if we'll decide which direction we're going, and depending on the motion, will depending on whether I hear from you today. Okay, thank you for your patience with us. Commission, first of all, I'm going to ask, do you have other opinions or expressions you'd like to make? And secondly, then what I would say is, I would ask for a motion to either deny standing or to hear or arguments on standing at our next meeting. So I'd like to ask for one of those two motions unless there's further comment from the commission.
Commissioner Baker. Mr. Vice Chair, members, I would move that the commission schedule oral argument on the issue of standing, also a possible decision on the issue of standing, the May 9th meeting. Second.
We have a motion and a second. Pam? Discussion? Any further discussion? Pam, could you?
Certainly. Commissioner Brankard, your vote is? And Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Commissioner Armstrong? Commissioner Armstrong, your vote on? Yes, sir.
Yes.
Thank you. Commissioner Rader?
Abstain.
Vice Chair Cipher?
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlin.
Yes.
The motion passes.
Thank you.
Vice Chair,
Cipher,
Yes.
before we move on, I have a question for Hearing Officer Kalen. Hearing Officer Kalen, we can do one of two things. Either you can further amend your scheduling order of March 15th to include the oral arguments on the issue standing for the May 9th, or I can simply bootstrap your amended scheduling order and incorporate the decision of the commission this morning, whatever your preference is.
Thank you, Council Sanchez. I'll issue a second amended scheduling order. And Vice Chair Cipher, that concludes my business before the commission this morning. May I be excused?
Absolutely.
Thank
Thank
you,
you.
Vice Chair Cipher, before we let the hearing off.
Okay.
I didn't let him get off the hook, buddy. Although we didn't cover it in the motion, I think the hearing officer could address the time limit on oral arguments on standing. He can address that within his schedule.
I will do.
That's awesome. Thank you.
Thank you.
Now you may go.
Oh, good. Thank you.
Vice Chair Cipher, before we let Hearing Officer Kalen go, I really want to thank him for, this is a note of appreciation for all the time he's taken to address all these very complex issues and for laying out a very good chronology for the commission on the issue of standing. Mr. Shkalin, I appreciate it, and I think the commission does as well. Thank you.
Thank you, Council Sanchez.
Thank you. Okay. That brings us to item 10 on our agenda, WQCC number 2201, in the matter of the petition for a permit review of discharge permit renewal modification, DP 873. The joint motion was not timely on this. As an introduction, there was a joint motion filed, and it was not received by our council, and it was only available like a day before. However, I am willing to hear from the parties regarding that motion if they're both available. I guess that would be Councilor Tencio, and then Captain Jordan. Is Captain Jordan here?
It's Major Jordan.
Major Jordan, excuse me.
Hi, yes, this is Major Jordan Davis. I'm on today.
Okay, great. My agenda has you down as captain, so my apologies.
No problem, sir.
With that, Councilor Tencio.
Thank you, Vice Chair Cipher, members of the commission. I'll be brief. As it states in the joint motion, the department is engaged in court structured mediation in the 10th Circuit regarding a resource and corrective action permit issued by the department's Hazardous Waste Bureau for Cannon Air Force Base. Without getting into the details of that, the discussions have broadened and may touch on DP 873 in order to continue those talks and avoid the possibilities of having to expend additional resources on timely appeals and filings and that matter. The parties apologetically at the late hour decided to request a stay for that purpose in order to continue talks, which may involve this matter before you today. That's all I have on that, and would defer to Major Davis on anything else.
Thank you. Major Davis.
Good morning, everyone. Yes, I agree with what Mr. Tencio said. The parties agree that it would be best for us to continue these discussions at the 10th Circuit Mediation Forum to avoid wasting resources in this forum.
Two points to both Mr. Atencio and to yourself, Major. And that is that, number one, if you would like to file something to this body in the future, please make sure that it does go to our legal counsel, and number two, that it be timely. And then number two, this is not an endless stay situation. We would expect that if this commission grants a stay on this, that we would include in our motion a time frame that would be met. Would you both be open to that?
Vice Chair Cypher, members of the commission, my clients authorized me to agree to a 90-day stay.
Thank you. Major?
Yes, sir. We agreed to the 90-day stay as well. And one more thing I wanted to point out about the joint motion for stay is, in addition to a stay on the proceedings, there are certain permit conditions, the contested permit conditions related to PFAS that we've also agreed to put a pause on for that 90-day period.
Council Sanchez, would you please weigh in on this situation?
Vice Chair Cypher, I would do nothing more than echo the 2 points you've already raised. I don't want us to get into a situation like we did for 2221, where we're waiting for the EPA board to issue a decision that we thought was going to inform the commission's deliberations, and it just it ends up being this very long process with not a helpful outcome, and the commission ends up being a body that is kind of a placeholder for other proceedings, and I just really would like to discourage that. That's my only comment, or comments rather, Vice Chair Cypher. Thank you.
Thank you, Council. Would you please opine on the 90 days? Is that excessive? Is it too limiting? What's your thought?
It sounds to me from what Council is saying is that they have looked at the 90 days relative to the other proceeding that may, and those are the words of Council Atencio, may inform the commission in this proceeding. So I'm going to trust that they have looked to that proceeding and the time it may take to resolve itself or issue a resolution that hopefully, and again, it's may, inform the commission in this proceeding. Thank you.
And one last question, Councilor. So in the event that it is the will of the commission that we grant this stay for 90 days, is there any additional order or paperwork that would be required to initiate that?
Vice Chair Cypher, let me go back a bit. The present posture of this proceeding is actually a bit unique and perhaps awkward. If the commission will recall, the last time the commission went into executive session, and what the commission decided is Hearing Officer Kalen had entered an order supplementing the record. The supplemental evidence had not been considered by NMED. So basically the commission ordered it wasn't a remand, but the commission ordered the party or NMED to consider that supplemental evidence. And we didn't quite get a response, or at least not one that I had expected from NMED. We had Cannon Air Force Base basically responding to what was a notification by NMED. So it's become a little convoluted. It's now uniquely postured, and I'm really hoping that we can finally conclude this.
Okay. So would a motion include any additional orders, or would if we were to make a motion for a stay, is the motion limited to that this body, recommends a stay, or will allow a stay and then give the 90 days? Is that sufficient?
That would be sufficient. And I would ask if that is the decision of the commission to grant the 90-day stay, that council, again, I haven't been served with any pleadings, so I don't know if they submitted a proposed order along with their motion, but if they did or didn't, I didn't get one. And I'd like, depending on what the commission decides, get a proposed form of order on the 90-day stay. Thank you, Vice Chair.
Council Atencio, had you submitted any written material other than the order?
Vice Chair Cipher, members of the commission, I believe Major Davis submitted a proposed order that the parties had agreed to with that motion.
Can you see to it that that order is copied to Council Sanchez, please?
Yes.
I appreciate that. Thank you.
Vice Chair Cipher, couple of quick comments. By no means is this particular matter a routine permit review. It has a lot of complexities to it and appears to have a lot of moving parts also. So I agree with your comments about the timeliness issue, but this commission does like to have stuff tied up in the bow, but given the fact of the complexities of this permit review and that if some things can get resolved, I think the state may provide some light at the end of the tunnel. And so with that said, I would make a motion that the commission approve the 90-day stay that has been requested by the parties.
Thank you. Is there a second?
I make a second, but I also like to make an amendment. Have the stay be until our July meeting. And then have the parties report to us at the July meeting. So that we have a process for reviewing.
Do you accept that, Fender?
Yes.
I can't say the word friendly amendment.
Yes.
Exactly. Mr. Mayor, we have a first and a second. Any further discussion?
Ready? Commissioner Brankard, your vote?
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Armstrong, Commissioner Rader,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson, Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlik.
Yes.
The motion passes.
Thank you, Pam.
Chair Cipher,
Yes.
might I request that we have a brief break, 5-minute break and reconvene at 10:40?
That would be great. Let's do that. Thank you. We will be back at 10:40. Thank you. I think we are ready to proceed. Is everybody here? About Pam.
She left to the bathroom. She should be back.
Okay.
Yeah,
So
I started the recording.
you started
Yeah.
the recording. Okay. That is great. With that being said, I believe that takes us to item 11 on the docket. The agenda, WQCC number 23-12, ELK Black River Mainstream. This one, Council Sanchez, I'd like you to talk just a little bit about, there's a potential timing issue. But assuming that this was filed in what will be found to be a timely manner, in that case, I believe if we follow our normal procedure, and I need guidance on this, but our normal procedure would be to provide a hearing officer and waive the 90 days. Am I saying that right, council?
Thank you, Vice Chair Cipher. There's actually a couple of concerns regarding these two petitions, and they relate to, one of them relates to action taken by the commission regarding the previous petitions for review that were filed by Mr. Rose. They all these petitions stem out of the October, what was it? The October 2nd, I believe, October 3rd, rather, notice issued by Oil Conservation Commission Director, basically saying that all these folks had to get apply for discharge permits. But the first concern for me is, if you will, when we're considering the 9 petitions filed by Mr. Rose, the question became how the commission should proceed. The longstanding practice of the commission has been to issue an order granting the petition for permit review, appointing a hearing officer, and having the parties waive the 90-day limit. In this particular case, really at the instance of Commissioner Brankard, and if the commission will bear with me, we were looking at the language of 7465 P, which deals with appeals from permit reviews. And that language says, if a timely petition for review is made, the commission shall consider the petition, and then within 90 days. That's where the Commissioner Brankard made the argument that there was no granting of the petition per se, that it was really a ministerial act. And Commissioner Brankard, I apologize if I'm misstating or mischaracterizing your position, that it was basically a ministerial act. There was no need for entry of an order of the sort that I've mentioned. And so we didn't do that with respect to those 9 petitions. Landed up having you be the hearing officer, absent the appointment of another hearing officer. So if I'm not sure how we're going to handle these two, that's the first question, whether we're going to go back to the longstanding practice of the language of granting, entering an order, granting the permit, the petition, appointing a hearing officer, and having the parties waive the 90-day period, or proceeding as we did the last time, or as the commission did the last time, which is simply to treat the filing of the petition as a ministerial act and then not enter the sort of order that I've mentioned. So that's really the first question. The second question regarding these 2 petitions is the Oil Conservation Commission Director entered her notice on October the 3rd. I'm looking at the 2 petitions that were filed most recently, and it says that although the notice dated October 3rd, 2022, oh, I'm sorry, my apologies. Although the notice is dated October 3rd, 2022, DLK, and I assume the other petitioner states this as well, did not receive the notice until January the 5th, 2023. So we have the whole question of whether the 30-day period to file the notice, the petition, was timely. It would seem to me like there would need to be a showing at some point that notice was actually not received by these 2 petitioners until January the 5th, 2023. And I kind of mentioned as a sidebar, if this had been rulemaking, as some of us think it was, there would have been publication of notice, post publication in the register, so we wouldn't have this. Well, some of us received notice on one date, and the rest of us received notice on a much later date. But those are basically the 2 concerns. Thank you, Vice Chair Cipher.
Thank you. So Commission, Council Sanchez has said that we had a long-standing methodology that we chose not to use in this case. It seems to me, unless there's opposition, that moving back to a long-standing practice where we would appoint a hearing officer and ask for a waiver of the 90 days from the petitioners, I believe that is, that might be the standard practice we want to use. And if not, I'd like to hear your opinions on that topic first. Hearing no responses, it doesn't sound like anybody would be opposed to going back to our long-standing method unless Mr. Dominguez, I'll recognize you.
Thank you, Mr. Vice Chair. I guess, a little bit of the conundrum that we're in is we have the group that we've already handled one way. And now we have another party on the same subject matter. And if we want to handle that differently, then we get a mixed bag. Or if we want to somehow try to lump this in with the other group that we've already built. I didn't really give you a solid path there. I'm just pointing out that we're going to be.
We would have to go. We have a couple of options. I think what you're saying, we would have to go back and if we're going to stand with the law or go with the long-standing methodology, then we would have to retract or in some way go back on the first one. Council Sanchez, you've got your hand up. Are you going to answer that question?
No, I think the choice that Commissioner Dominguez identified as have you is the correct choice the commission has to make. But I just wanted to mention that when we go to item 12, we may have to revisit this question again because the last report that was filed by the parties is that we issued a stay there again without granting a order or entering an order granting the petitions, of which 4 only remain on the docket. But the last status report indicated that the parties have made no further progress. They're, I guess, at a standstill. So the question when we get to that related agenda item is, how are we then going to proceed since we have not, or the commission hasn't entered any kind of formal order granting the petition for review, appointing the hearing officer, or waiving the 90-day period? Just wanted to let the commission know that we may well be asking the same question when we get to item 12. Thank you, Vice Chair.
Well, that didn't help much, but then I think, do you see, Council Sanchez, do you see a way? I tell you, it makes me so comfortable to be able to go back to an established procedure. If we did that for item 11, contingent upon them proving their timeliness, what could we do to unblow the whistle, as it were, on item 12 and get a hearing officer and handle this the way we've traditionally done it, if that's the desire of the commission? Commissioner Branker has his hand up, so let's go with his first.
We're all here so we can decide on whatever process we want to decide. So I think a lot of these decisions were made in between hearings. when there was nobody, there was no commission meeting and something, you had to do something,
Right.
okay? And if there's no hearing officer, you're the hearing officer,
That's me, yep.
right? So, that's how the process works. I guess the threshold question I think to ask in this case, 23, 12, 13, is to ask the parties, are they willing to waive the 90-day deadline?
Okay.
We can't do it for them. They have to be willing to do it.
Okay, great question. Are the parties here present? Would you help us as a commission discover the answer to that question?
Mr. Vice Chair, Commissioners, my name is Adam Rankin. I'm appearing on behalf of the petitioners in both these cases with the Santa Fe Office of Holland and Hart. Good morning. Thank you for hearing me. As to the question about the 90-day period, I can tell you that both clients that I represent here in these petitions have agreed to waive that 90-day period. And as I understand by the Commission's rules, a motion should be filed before that 90-day period runs, which in our case would be May 4th. So Mr. Tremaine, who is my counterparty here representing the division, he and I have discussed this, and we have both agreed to waive that period to enable us as parties to engage in discussions to potentially either resolve our petition or to narrow the scope of what's at issue.
Sir, are you referring to when you say both? Because we have two items on the docket, and then there are also two items in WQCC number 23-12, which is 23-12 and 23-13. Are you referring to those two when you say both?
To clarify, Mr. Vice Chair, I'm referring to both petitions under item 11 on the docket, WQCC item number 23-12 and 23-13.
Thank you.
If I may ask another question, are parties in 23-12 and 23-13 going to consolidate their appeals with the cases under item 12, 2255, and so?
Commissioner Brancard, Vice Chair Cipher, Mr. Tremaine and I have discussed that possibility. At this time, I think we'd be unwilling to do so. The timing is so different between our posture and theirs. The other groups have had an opportunity to meet and have had some technical discussions over the nature of the petition. We have intended to do so ourselves, and we'll be meeting, we're looking at early May dates for potential technical review to discuss our petition and the division's concerns. And so we think the timing at this point anyway is such that it's not appropriate to combine them. So setting aside the timing, we also have concerns about lumping them together due to potential factual differences in between the different facilities at issue. So at this time, and I believe Mr. Tremaine can speak for the division, our request would be that we keep these matters separate from the other items before the commission.
Thank you, Councilman. Commissioner Branker, would you share with us kind of what you were thinking in asking those questions as it would apply to moving forward?
Well, what the commission did with the other cases was simply allow the parties the ability to have discussions. So there was no really need for a hearing officer to start scheduling briefing, et cetera. That's what the parties would do. That, I don't know if that's the situation now with the other cases, but with this case, the parties simply wanted a time frame to discuss matters. And it may be best to give them a time frame to come back to the commission and report where they are. And then if they're ready to then have a formal permit review, or if they've worked things out, let us know. So that would be my suggestion, I guess, for these two cases, and I think council can respond, is simply say 60 days, 90 days, come back to the commission and report to us on the status of discussions and whether you're ready to go for a formal permit review.
So waive the 90 days, have
Right,
them
that would
waive the 90 days, And then we ask when they would like to come back.
Correct.
Vice Chair Cipher, Commissioner Brinker, thank you for raising that, and I should have probably included that in my dialogue with y'all at the outset. But yes, we have Jesse, Mr. Tremaine and I have discussed, and we had intended in advance of today's meeting to file a motion setting that out, a request for the 90-day, perhaps a 90-day stay of all proceedings, and then a confirmation that we have stipulated to waive the 90-day period. And so our intention is after this meeting to continue our conferral and confirm the timeframe that we'll ask for. But probably, I think, in my view, 90 days would be the minimum given what we're hoping to achieve between now and then in order to allow the parties to have the technical discussions. And I think Mr. Tremaine's going to be gone for a bit. So 90 days, in our view, would be more than appropriate to allow the parties to try to engage in discussions.
And so for our July meeting, that would be acceptable to you?
I believe so, and I would ask Mr. Tremaine to confirm for his part on behalf of the division.
Yeah, thank you, Mr. Rankin. Sorry, this is Jesse Tremaine for the Oil Conservation Division. I'm appearing by WebEx. I apologize, I was not clear when I was supposed to jump in there, but I do agree with Mr. Rankin. We have discussed this, and my apologies, we did intend to file a motion in advance of this hearing. Speaking to this matter, we do agree to waive the 90-day requirement and agree that a stay of 90 days is appropriate for 23-12 and 23-13.
Thank you. So Commissioner, I didn't mean to step on anybody's toes in saying how we're going to handle this, because that is not my purview. I want that to be your decision as such. And I'm not be here anyway, so I want to respect that. But I think what I've heard here would be a good solution for item 11 on the docket. If you agree to that, I would appreciate a motion. If not, let's go back to the drawing board and talk about something else. Because I think Commissioner Dominguez had a good point, and that is we would be going back to the norm, all right, but we would be doing it differently than we have done before. Yes.
In that regard, Vice Chair, I think it's up to the commission. If we agree to this process, if they can come back in 90 days, there'll be a motion filed. Then the question is, who responds to that motion? And we can do it like we've done in the last case, which is the chair can respond and issue an order to so granting the motion because the parties are in discussion. Or you can go back to the process the commission has done in the past, which is let's just appoint a hearing officer now and they can handle the procedural motion. Yes. So I think that's up to the commission with.
Absolutely. Yes. Anybody like to take a stab at a motion? Or do we need more counsel from Council Sanchez?
Vice Chair Cipher, you don't need any further counsel from me. Thank you.
Thank you.
Mr. Chair, I'm prepared to make a motion.
Okay, great.
I move that we allow time for negotiations between two parties and that we reconsider this at the July meeting. So I don't know if it's exactly 90 days, but we'll get it. Issue will come back up.
And I've been told by Commissioner Dominguez that a verbal acknowledgement of the waiver of 90 days is what we've accepted in the past. So we've heard that today, and the minutes would reflect that, and we are in good shape there. And then as far as appointing a hearings officer, would your motion include that?
No, I think we considered that. Reconsider that at the July meeting.
Okay.
A second.
Any further questions? Pam, roll call please.
Commissioner Brinker, how do you vote?
Yes.
Commissioner Candelaria? Yes. Commissioner Dominguez?
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Armstrong,
Yes.
Commissioner Rader,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil, Commissioner Zemlin.
Yes.
The motion passes.
Thank you. Brings us to item 12.
Vice Chair,
Yes,
Vice Chair Cipher,
yes.
just so I'm clear here. So then, just two things, I guess, is resulting from this. One is on we're accepting the oral stipulation of council on the waiver of the 90-day period with nothing, with no entry of any particular order or anything. That's number one. And number two, we should be expecting council to file a stipulated motion requesting a 90-day stay until, stay until the July meeting. Is that my understanding what we'll be expecting here?
I believe that's accurate. Yes.
Okay, thank you.
Vice Chair Cipher,
Yes.
just for clarification, any procedural matters during this interim period, the chair would handle those as the hearing officer
Yes.
during that time.
That's what I tried to point out.
Yeah.
And I think you were clear on it, so that wasn't, that was no surprise, so it's good.
Just so that Commissioner Thompson can add that to his plate.
Yeah. Thank you. Okay, are we ready for item 12? Item 12 on the agenda. Councilor Sanchez, now that we have done what we've done with 11, what is your counsel to us on 12? Is the
Commissioner, I just lost,
Yeah, pardon?
Vice Chair Cipher,
Yes.
I just lost connectivity, so I don't have access to the docket. But I'm recalling, and Mr. Rose can correct me if I'm not recalling this correctly. The last status report that they filed was that they were making no further progress, or there was an impasse on the time that was given to them by the commission to work things out. So we now basically are at the point where, and again, it's the same question. I assume the commission then just sets a matter up for hearing on the permit review. And I guess, and I'm sorry to sound a little uncertain here, but I guess answers to just a single order appointing a hearing officer. But we're kind of back to square one, since the parties are telling us that they have made no further progress in their negotiations. Thank you.
Would you like to update us? Is that still the case?
Yeah, Mr. Vice Chair, for the record, my name is Louis Rose. I'm an attorney with Montgomery and Andrews, here representing Target DCP, and that's correct. And Mr. Tremaine can certainly wade in to clarify that, but our position is that no further discussion is going to resolve this, and so we need to go through the commission's process and review. We did in our petition ask for remand back to the division because there's no factual record was developed. The only, as far as I know, the only administrative record in this proceeding is the department's notice to the parties basically requiring that a discharge permit application be submitted. So what we've talked about with the division is potentially coming up with a stipulated set of facts for these facilities and then setting out a briefing schedule. And I think the path forward would be for the commission, assuming, Mr. Vice Chair, that you're not willing to be the chairman or be the hearing officer in perpetuity, that you appoint a hearing officer and then leave it to the hearing officer to figure out with the parties a process moving forward. So, like I said, I think we need to go back to square one at some point, but for us, square one would be developing a factual record on these facilities for the commission then to to review the determination of of a permit required. But like I said, I think we don't need a hearing in front of OCD, that we can come up with a stipulated set of facts on which to try this, but I would leave it to the hearing officer to develop that procedure. I think is the most effective way to do that. And as to the issue that you raised in the last agenda item, since we've already exceeded our 90 days and it was based on our motion, if we need to formally enter a waiver, we can certainly do that too.
You would give us a verbal waiver.
I think we already have, because you've extended the time period at our request long beyond that 90 days. So I think we have waived it. I could verbally give it, or if you want it in writing, we could certainly do that as well.
Verbal is accepted and we'll have it in minutes.
And other than that, I'd leave it to Mr. Tremaine to fill in the blanks here if I forgot something.
Mr. Tremaine?
Apologies, Vice Chair, I was muted here. Thank you, Mr. Rose, for that. I do agree with Mr. Rose's presentation. We have had ongoing discussions, but we are at a point where I believe it's appropriate to identify a hearing officer and get this on a briefing schedule. And I also agree with Mr. Rose's representation that there's a very limited, factual record here. I think that there are relatively discrete legal questions posed by the petitions, which this commission will ultimately need to weigh in on, and that the parties are in a position to stipulate the necessary facts to allow the commission to review those legal questions. And I would reiterate the division's waiver of the 90-day requirement for item 12 for WQCC numbers 22, 55, 56, and 57.
Thank you very much. We appreciate that. With that, Council Sanchez, what I'm understanding is the next step would be to have a motion to appoint a hearing officer, or am I missing something?
Vice Chair Cipher, you're not missing anything. That would be the next step. And in that regard, the commission has historically followed two options. One is to name a hearing officer today, or to leave it to the discretion of in this case, Commissioner Thompson or Chair Thompson to appoint a hearing officer. The order can go either way or read either way. And just with regard to the 90-day period, the commission will recall the argument had been that the 90-day period didn't begin to run until the parties had ended their settlement negotiations. So as peculiar as that may sound, technically, at least on the record, the commission has not run afoul of the 90-day period. Thank you.
Thank you, Council. There's some logistics that cause us some consternation on our appointments of hearing officers. And I really like the way, at least in my tenure here, that the commission has handled it, and that is to give the chair the authority to appoint the hearing officer. If you agree to that, Commission, I would appreciate a motion. Yes.
Mr. Vice Chair, I just want to raise a question I think that Mr. Rose brought up and Mr. Tremaine commented on, which is the lack of sort of a well-developed record at this point on which the commission can take action. The parties seem to agree that they would work together to come up with a record, but that's not really part of our process, and we kind of ran into that problem with the Canada Air Force Base case also. So I'm wondering, and I will throw this at Mr. Sanchez, whether it would be more proper under our rules to, at this point, formally remand this back to the agency for the development of a factual record on which this appeal could be based.
Councilor Sanchez?
Thank you, Vice Chair Cipher. Commissioner Brankard, yes, I think that'd be appropriate, because otherwise I think, have the parties stipulate to a set of essential facts potentially would hamstring the hearing officers. So I think the preferable thing to do is in that order, remand it to the Oil Conservation Division for development of either a record or stipulated facts and appoint a hearing officer. Thank you.
So we would do both, Counselor?
That's correct, if that's the commission's pleasure.
Thank you.
Are the parties willing to agree on a time frame for coming up with a written record? So the hearing office.
Mr. Chair, Commissioner Brankard, I suppose, I mean, we hadn't thought about what it would take to get that done, but I'm not opposed to any kind of time frame built into it. And I can't remember if your rules actually, they spell out the process of a remand to the agency, but I don't recall if there's a timeline built into it or not, so. But if you want to build in a timeline to get that done, I would guess, I don't know what Mr. Tremaine's workload looks like or whatever, but I would guess somewhere in the neighborhood of 60 days would be sufficient to put that together.
And yeah, I like to hear from Mr. Tremaine because the way the remand works is we're remanding it back to the agency. The agency develops the record then, and then the agency comes up with a decision if it's any different than what they started out with. And so we just need to have that process put in place and what it might take the division to come up with that decision. And then the hearing officer can proceed with briefing, et cetera, following that. I mean, that would basically, it would trigger a new permit, a new 90-day permit review process. Was my reading of it.
And Mr. Chair, Commissioner Brankard, I'm not sure that it does. I think it's all part of the same proceeding, but the statute's not altogether clear in terms of how it works. And I don't know that the commission's done it very often. I know it's done it at least once in terms of a remand for development of a factual record. So I think the report comes automatically back to the commission to restart the process, but I don't think any kind of appeal is necessary. So there wouldn't be any kind of procedures that we would need to initiate so much as the division would have to report back to the commission, and then the commission's process would take effect at that point. So if you want to, like I said, if you want to build into timeline to that, we can that's certainly something we can deal with. But like I said, I don't know what the department's schedule looks like and whether it can accommodate 30 or 90-day process.
Well, maybe the parties can work together to come up with the hearing officer to come up with a schedule. I mean, I'll just read the rule here. It says the review date, the permit review shall be scheduled to begin more than 90 days after the date of permit review petition is received, or 90 days after the date the department files the additional evidence received and action taken after a remand. When we remand it back, the department develops the factual record, issues a decision based on that factual record, then the 90-day clock begins again. Thank you.
This is, if I may, this is Jesse Train for the Oil Conservation Division. Understanding, I think, where we're going with this process, if this is what's decided upon, I think in terms of the remand, I think 60 days is, I would ask for 90 at this point, simply because I'm happy to report that I will be out of the country for slightly over 2.5 weeks here. And I'm going to be the one working on this. So by the time I get back, we're going to be working with the 60-day deadline for that. So I think that would also benefit the division and myself because it would put items 11 and 12 on a kind of a consistent schedule before this commission.
Thank you, Mr. Tremaine. You want to take a stab, Commissioner Riker, to motion?
Okay, so, there has to be cause for a remand, and so I'll start with it, that, the parties have shown that there was not a reasonable opportunity to submit comment or evidence, related to this matter before the agency. And so therefore, the commission is authorizing a remand to the Oil Conservation Development Division to develop a factual record and issue a decision based on that factual record with deadline of 90 days from today to develop that. We would also authorize the chair to appoint a hearing officer to oversee this process.
I think that was done well. Thank you.
Like a mouthful.
It was a mouthful, but it had all the elements. Thank you. Is there a second?
Second.
Okay. We have 2 seconds. So whoever you caught.
I caught Commissioner Dominguez. This is, so I was looking at him.
Roll call, please.
Okay. Commissioner Branker, your vote,
Yes.
and Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Armstrong. Thank you. Commissioner Rader,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemlin.
Yes.
Motion passes.
Thank you. That moves us to item 13 on our agenda.
Commissioner, I'm sorry, my apologies, Vice Chair Cipher. I'd ask that council submit a proposed form of order to me, please.
Understood. Thank you.
Got it.
Thank you, gentlemen.
Thank you. You're having too much fun up there. Commissioner. But, you know, I think I get the last laugh after today. Wonderful tweet. Okay, so on WQCC number 22-45, Mr. Sanchez, this was Gregory Chicanas, I believe. Do I have that right?
That's correct.
And
And Vice
advice,
Chair Cipher, what happened is the hearing officer filed his report and recommendation on the 27th, and NMED and the petitioners filed their responses, which I believe concurred in the recommendation of the hearing officer.
okay. So we need to deliberate.
Yes, I think the commission needs to decide whether it wants to adopt the recommendation of the hearing officer or proceed otherwise.
Okay, comments?
Mr. Chairman, I just wanted to let you know, this is Pete Domenici. I'm here for the petitioner. I don't think my camera's working. Let me see, maybe I can get it. There it is. Thank you. I'm here. Just so people know I'm here.
Thank you for making us aware. Commissioner Dominguez?
To keep things moving along here, in one of the new commissioners that was actually part of this original alternative, I think, standard here a couple of centuries ago. You know, this particular request is a little bit unique, but alternative abatement standard petitions are rare within themselves, but having gone through, read the hearing officer's report, I think the petition is logical when it's the petitioner's request is logical in order to address the property issues there, and there appears to be no negative impacts resulting from this revised abatement standard request. So with that said, I would make a motion to approve the petition for alternative abatement standards in WQCC 22-45 and to adopt the hearing officer's findings, effects, and conclusions.
Second. Anyone have a second? Any further discussion? Would you please take roll?
I will. Commissioner Brankard,
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Commissioner Armstrong. Commissioner Armstrong, I didn't hear you vote.
Yes.
Thank you. Commissioner Rader,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Vehil,
Yes.
Commissioner Zemler.
Yes.
Motion passes.
Counselor Sanchez, you have your hand up.
Yes, thank you, Vice Chair Cipher. Mr. Domenici, my recollection is that this is going to require the filing of an amended covenant with the Sandoval County Clerk's Office. And I think you introduced that at the hearing at one point, but just to make sure that I have that, would you send that along to me or rather just send that along to me? That way I can make sure that it's attached to the order that's entered by the commission. Thank you.
Yes, I will. I'm sorry about that. It's referenced in the recommended decision as Exhibit 1, but it's not attached. So I'll send that directly to you, sir.
Thank you.
Mr. Sanchez, this is Lorraine Hollingsworth, also at the Domenici Law Firm. We have a redlined version and do you want a redlined or a clean version of that deed restriction?
I'd rather have the red line version. If it's track changes, I can then go ahead and decide whether those track changes are appropriate or not and accept them or not.
I object to that. There's an attachment on the recommended decision that's been moved and approved, and we don't expect to have our deed revised again. The form of the deed was reviewed by the hearing officer and was just approved. So we're happy to send it to you, but we don't expect to get a red line back from you, sir. This has been decided.
Well, Mr. Domenici, it was your colleague that raised the question. I'm not sure why she did that, so.
But a red line will
I
show
have
you.
no problem with that.
We'll send you the red line so you can see the changes clearly. So we're happy to do that. And a clean.
That'll work.
Okay, thank you.
Thank you, Council.
I have nothing further, Vice Chair Cipher.
Thank you. And we had a passing vote, Representative.
Yes, you did. Yes, sir.
So item 14 is the next WQCC meeting date and upcoming commission matters. The date that I had was May 9th. Does anybody want to opine or amend that date? Okay, so that is the next date. And upcoming commission matters, was there anything not discussed today that you had questions on or wanted to suggest? Hearing none, we'll go to item 15, which is adjournment. This meeting is hereby adjourned. And yes,
Well, I just, on behalf of all the other commissioners, I'd like to thank Vice Chair Seifert for all his work. Stepping into the breach here.
created some good laughs in this.
Vice Chair Seifert, I would like to echo Commissioner Branford's comments and having been down that path myself, I do that. Workload can be a little bit onerous at times, so we do appreciate you stepping up and handling things through this interim period. So, and before we completely adjourn, quick question for the commission administrator. And for the May 9th meeting, I'm assuming the commission would be convening in the state capitol as we typically do.
I hope so. Yes, the room was not available on short notice this time, but I will get right on it to get it for next month.
Okay, thank you.
Thank you.
Did you send the details of that location?
I sure will. Yes.
Well, it's been, it really has been an honor to serve, the governor in this position, and it was a good learning experience, and I enjoyed it. But I'm going to, probably enjoy my time. I get to clear off my desk and see what I haven't been doing. So, thank you all very much.
Thank you.
And best to you all. Thank you.